Hi, everyone, and thank you for joining. We're going to let everyone continue to log on, and we'll get started in just a few minutes. All right, let's go ahead and get started. Hi, everyone. Thank you for joining today's webinar, Healthcare Prosecutions in the Aftermath of COVID-19. Today's program will be presented by Matthew Adams, partner and national co-chair of White Collar Criminal Defense and Regulatory Compliance at Fox Rothschild, and Jessica Hollobaugh, partner and market leader of Withum's Forensics Investigations and White Collar Criminal Defense Group. Before we begin, I have a few notes. Today's materials can be found in the toolbar on the right of your screen. Also, at the bottom of the toolbar, you will see a questions box. Feel free to send us your questions during the presentation. We will do our best to address them at the end. There will be 4 polling questions throughout the program. To qualify for CPE credit, you must participate in each poll. CPE certificates will be emailed to you within a few weeks. And finally, once the webinar is over, there will be a pop-up asking you to complete a survey of today's webinar. Please take a moment to complete it. It is our way of being able to provide you with the best and most relevant programs possible. With that, I'll turn it over to Jessica.
Good morning. Thank you, Rachel, and good morning, everyone. Thank you for joining us. As Rachel mentioned, I am Jessica Hollobaugh, and I am a partner at Withum and the market leader of our Forensic Investigations and White Collar Criminal Defense Group. In that role, I am often engaged by counsel, such as my panelist, Matthew Adams, to assist with the financial aspects of a multitude of investigations, ranging from kind of your run-of-the-mill embezzlement matters to all types of government enforcement and regulatory actions. So most recently, post-COVID, many of those investigations have revolved around PPP and other government programs that have infused trillions of dollars into the economy. Matt is a partner at Fox Rothschild and is a co-chair of their white-collar criminal defense and regulatory compliance practice group. That's a mouthful. He is also a vice president of the Association of Criminal Defense Lawyers of New Jersey. And Matt's experience as a criminal trial lawyer, he has represented a wide range of clients in various criminal and regulatory defense matters throughout the United States. And specifically with respect to the healthcare industry, Matt has handled many high-profile cases, including the representation of one of the lead defendants, Matt, in what has been designated by the DOJ to be the largest alleged government billing fraud in American history. So Matt clearly has a wealth of information based on his experience, and we thank you for joining us here today.
Thank you, Jess.
You're welcome. And before we get started, this wouldn't be a presentation from a criminal defense attorney without a disclaimer indicating what his presentation represents. But secondarily, I just wanted to note that today's program is intended to be as interactive as possible with a virtual program. So there is a questions box on your Teams screen. So feel free to post your questions there. I will monitor those questions and we'll try to get as many answered as we can throughout the presentation. So Matt and I have had the opportunity over the course of the past year or so to both work and speak together frequently with respect to a very broad range of government investigations that have been arising in light of the pandemic. But we are going to do here today is kind of take a more defined look at that and focus specifically on the healthcare industry. And Matt, the healthcare enforcement certainly isn't a new trend that has arisen as a result of the pandemic. And in fact, the government has historically been very proactive in their prosecutions related to healthcare fraud and abuse, arguably the most of any industry. So before we hop into the post-pandemic trends and what you expect to see there, can you start by talking a bit about what the enforcement activity within the healthcare industry looked like before the pandemic?
Sure, and thank you, Jess, and thank you, Withum. I've come to value our relationship with Withum greatly. It's no longer that we're just periodic collaborators. It seems almost that with the complexities of the matters that we're handling, we're engaging with them almost on a daily basis, it seems, and especially in the post-COVID-19 environment, with the just significant uptick in financial investigations. The partnership that Fox Rothschild enjoys with Withum is something that I value greatly, and I'm very grateful for the opportunity to come and speak to you guys this afternoon. You did mention it, and in a lot of facets of our life, we have begun to view things from the lens of what was life like before COVID and what was life like after COVID. And the government's efforts in the healthcare industry with respect to healthcare investigations prior to the outbreak of the COVID pandemic, and I roughly place that line of demarcation at the early part of March 2020, was among the most significant uptick of any particular topic area in white collar crime. The Department of Justice and Health and Human Services for upwards of 20 years has annually released something called the Healthcare Fraud and Abuse Control Program Annual Report. That is measured on a fiscal year from October 1 to September 30th. So thus, the fiscal year 2019 report would run from October 1, 2018 through and including September 30th, 2019. And this is a very comprehensive set of data, but in particular, the time frame for the fiscal year 2019 annual report really provides us the most significant snapshot and comprehensive set of data associated with pre-pandemic enforcement activity in the United States. And at that point in time, before we entered into this pandemic era that we're currently living through. And I'll say, as somebody who's actually recovering from COVID themselves at the moment, we don't know how long this is gonna be. We don't know how long into the future we are going to be living in this environment. The hope is that there is a return to normalcy, but at this point in time, the COVID pandemic has really impacted every aspect of our daily life, and in no industry perhaps more so than the healthcare industry. But in this fiscal year 2019 annual report, some of the key findings that we can look to were really a $300 million increase in total judgments and settlements. That is fairly remarkable. Those judgment settlements come through civil and criminal means, and the enforcement actions brought by the Department of Justice and the HHS Office of Inspector General. And I think, just to put it into sheer focus, one of the truly astonishing facets of that is just the amount of money that these enforcement actions recover. Most of it goes back to the Medicare Trust Fund, but the reality is, in fiscal year 2019, the government collected $3.6 billion. Now, they can get judgments and they can be uncollectible, and that's what the $2.6 billion number looks like. But when it came to actual realization, they realized $3.6 billion in that period that we're talking about, just before the pandemic broke out, from October of 2018 to September of 2019. That's an increase of $1 billion with a B dollars compared to the prior fiscal year. And like I said, most of that goes back to the Medicare Trust Fund. That is a tremendous amount of enforcement activity, resulting in a tremendous volume of activity. Jess, if you could just step back from that last slide just for 1 second. I want to just highlight one more thing. The government, in compiling all of these statistics, estimates that in the fiscal year 2019, they got a return on their investment of $4.20 for every dollar spent on enforcement. Now, this is a very comprehensive, very expensive process to go after these alleged frauds, but the ROI over the prior fiscal year, 2018 for 2019, actually went up. So the government is not only doing this at an increased frequency, they're learning how to do it more efficiently. And that trend is something that, in light of the pandemic, is an interesting study. And Jess, you can go to the next slide. Thank you. I appreciate you going back.
Sure. Just a quick question with respect to the ROI and the improvement in that over the years. Do you contribute any of that to the government's increased usage of data analytics?
There's no question. There's no question. In almost every healthcare prosecution that I get into these days, there will be somebody in the room, whether it's an agent or another member of the investigative team, who will literally spit out statistics. Your client is among the umpteenth percentile of billers as it relates to this. And they know who the outliers are, and that's the starting place for many of these investigations. The government's ability to harness data analytics is unquestionably the single largest driving force behind the increased efficiency and productivity of these white-collar healthcare investigations. There's simply no question about it. As you look at that fiscal year 2019 data, and I call it pretty astonishing, you see large numbers of new criminal healthcare investigations. These are tracked. These investigations have to be entered into a centralized clearing system at the Department of Justice and HHS, which allows the government to say that they open this number of files in a given fiscal year. And while you might see some slight deviation from prior years, the reality is that they remain constant. One thing I hope to impress upon you today is that the scope and breadth of the enforcement activity is really best driven by the amount of money that they're taking down in these prosecutions. Because what these aren't just one-off prosecutions, and as I'll explain a little later, these are really concerted efforts to take down what they believe to be complex criminal networks. The number of defendants that were charged in criminal cases remained relatively constant prior to the pandemic, but these again are numbers that are at all-time highs. We saw a slight dip in white-collar criminal prosecutions throughout the Trump administration, and there's a lot of policy reasons for that, none of which are really political. The Department of Justice and the executive branch does get to set the investigative priorities for federal prosecutors. And through the 4 years of the Trump administration, we saw a shift in the paradigm in some regards, and I think anyone that was working in this area throughout those years would agree. We saw a lot more gang, drugs, and violent crime prosecution from the federal government rather than an emphasis on white collar criminal prosecutions. Notwithstanding that dynamic, however, though, I believe that healthcare really stayed firm. Among the white collar areas, healthcare continued to remain somewhat constant, and these statistics really bear that out. As it relates to HHS, so we have the Department of Justice, the federal prosecutors bringing actions. We also have the HHS Office of Inspector General, which has its own prosecutorial division, which can independently bring criminal actions. And in the fiscal year just prior to COVID, we see an uptick in that realm as well. Rather than being constant, they actually saw some appreciable growth in the number of criminal and civil actions. I'm sorry, just criminal, but fairly constant on civil actions. But that uptick in criminal actions represented to me a centralized way of handling these cases, where HHS has taken a more active role through the Office of the Inspector General, and that may very well be to some of the ways that they're building out large task forces that we're going to talk about in a little bit. Jess, if you would move into the next slide. Oh, we're ready for a polling question.
All right, here is our first polling question. The Healthcare Fraud and Abuse Control Program is a combined effort of what two federal agencies?
So give everybody a chance to go ahead and answer that question.
All right, about 15 more seconds.
Looks like most of you are getting it correct.
All right, I'm gonna go ahead and close it out. And here are the results.
So it looks like the vast majority of you got it right. It is the Department of Health and Human Services and Department of Justice. And the real power of that and the lesson behind that is the Department of Health and Human Services, or HHS, has its very own sort of prosecutorial office of the Inspector General that can be brought to bear to bring these cases alongside prosecutors from various U.S. attorneys' offices throughout the country. Jess?
Sure. So Matt, I know I've had the opportunity, like I mentioned, to speak with you many times about the government's current focus on pandemic fraud, which largely in the limelight has been PPP fraud and abuse. There have kind of been, two trains of thoughts that have developed on the future of healthcare investigations. One being that with the diversion of government resources to these other types of matters, such as PPP fraud, that the healthcare enforcement that we've historically seen may kind of fall to the back burner over the next couple years. Alternatively, the second train of thought has been, no, with this tremendous infusion of government funds into the healthcare sector, we're actually going to see increased enforcement activity. So can you talk to us a bit about kind of what we've seen? We have the opportunity now to look back to the last year and see what we've seen in that first fiscal year post-pandemic and what we expect to see going forward.
Yeah, absolutely. The starting place is this, right? We all know what's gone on. We all know in March, and this is just a collection of headlines that sort of led to the ultimate place that we're in right now, right? When I reflect back on March 13th of 2020, I know exactly where I was. I know exactly what I was doing, and that ensuing Monday, there was just a changed world that we all went into. Many of us couldn't go into our offices. We were relegated to our homes. There was administrative orders from governors across the United States to stay at home. We know what happened. That very moment in time represented one of the most monumental shifts in prosecutorial priorities, if you will, in the United States, perhaps measured only next to 9/11. After 9/11, we saw tremendous amount of federal prosecutorial and law enforcement resources going into counterterrorism at almost astonishing levels. So too did we see in March of 2020 incredible amounts of resources being placed at combating fraud and abuse associated with the then emerging public health crisis. And what we've seen in terms of now statistics that we can measure is while there was this divergence of prosecutorial attention from more traditional forms of law enforcement activity to combating matters associated with the pandemic, whether it be the price gouging that was associated with some of the scarcity of PPE and other equipment that were essential in those early days, or whether it be combating the entitlements fraud that was going on associated with things like the Paycheck Protection Program. Despite the fact that we saw that divergence, despite the fact that we saw all that prosecutorial energy shifting in the direction of those very timely topics, in the same manner that we saw with the sea change that occurred after 9/11. Despite that, now that we have another year of annual reporting for fiscal year 2020, it's apparent that the government didn't take its eye off of healthcare, despite the fact that they were pulled in just an incredibly large, different direction, perhaps unrivaled by anything we've seen other than maybe 9/11. That happened, and the statistics stayed consistent. There's recently been an OIG, Office of Inspector General, report from that's also demonstrated some of this trend line of pulling things to other directions. Notwithstanding all of that, we're seeing annual reporting showing that there is a steady amount of healthcare industry enforcement activity, and those key findings continue to show that the government is bringing down judgments and settlements in fiscal year 20 in the midst of the largest public health crisis in a lifetime, still upwards of $2 billion. They're collecting more than $3 billion. Yes, there's slight deviations from prior year highs in the fiscal year 2019, but in reality, these numbers are staying fairly constant, despite what was, by all accounts, a shift in priority that happened virtually overnight in March of 2020. Jess, could you move to the next slide, please? When you talk about it more quantitatively about the numbers of cases brought and what have you, it's very clear that the government is multitasking during the pandemic. There was essentially in connection with the annual report for 2020's fiscal year, it was essentially flat in terms of new cases, both civil and criminal. In connection with the number of defendants charged and the number of criminal cases brought by DOJ, you saw a slight decline in the number of defendants, but you saw you also saw those number of cases remaining fairly constant. OIG HHS remained actively engaged in bringing criminal prosecutions. Again, a slight decline, but significant numbers of cases. And frankly, you saw an uptick in the number of civil cases. All of this data then kind of leads to the simple question as to where we're headed. Where are we headed with criminal prosecutions, criminal investigations, civil claims, civil investigations by the federal government related to healthcare programs? We have this new variable mixed into the dynamic here with COVID-19, and what are we looking for? Well, many would say that we're headed to new all-time highs, and I think that there's a combination of factors present right now in the dynamic that lead to that answer being an affirmative yes. First and foremost, in 2020, the federal government formed what is called the National Rapid Response Strike Force, which is now operating in all 50 states and in every U.S. territory with a very, very high level of coordination. This is a basic attempt to target large multi-jurisdictional schemes healthcare schemes occurring across the country and indeed internationally. I'll tell you a short anecdote and story. I am involved. At the outset, Jess mentioned that I am representing one of the lead defendants in what has now been billed as one of the largest healthcare frauds in U.S. history. And this case is brought by the National Rapid Response Strike Force. When the case was originally charged, it was more of a local fraud section case, which is now morphed as they have begun to connect the various dots. And I can tell you that there's an international component to that case. It's a telemedicine scheme, or an alleged telemedicine scheme, whereby certain call centers were opened overseas at very low cost, and various telemedicine appointments were directed to prescribers, and certain kickback scheme was formulated throughout that network. That level of international coordination at the government's level, for an government investigation is no small feat. And I can just tell you, based on my own personal experiences in dealing with the various players in there, we have federal prosecutors based in DC, Florida, Texas, California. We have attaches in Colombia. We have international obvious components to this. In just 1 year alone of activity, the NRRSF touts that it has filed 263 new criminal actions, whether it be by indictment, information, or complaint, charged 405 defendants for alleged fraudulently billing healthcare programs, and private insurers, and they put the total of the alleged total fraud at 4.7 billion. Now, obviously, that number in just 1 year morphs entirely the number of judgments and other civil and criminal judgments and settlements rather that were secured in any year that has ever been reported in the 20 years that we've been reporting, and that's just happening in calendar year 2020. So when we see next year's report about fiscal year 2021, again running from October to September, I think we're going to see a dramatic uptick when we have the type of productivity by just one coordinated effort. That same, if you could just go back, Jess. That same strike force has touted that it's responsible for 254 guilty pleas thus far, and an enormous amount of trials in the COVID environment. I think anyone has a pulse for what's going on in the court system right now knows that the COVID environment has dramatically decreased the number of trials. But notwithstanding that, throughout the United States, the NRRSF has taken 24 cases to trial with guilty verdicts against 30 defendants. And they further published statistics that suggest that they've now secured imprisonment for 204 sentenced defendants with an average of nearly 42 months incarceration per sentenced defendant. So we're talking about very high value prosecutorial response from the National Rapid Response Strike Force. Now, Jess, if you could advance the next slide, there's also some other variables at play as well, and some of them are perhaps obvious, but COVID-19 itself has really created a significant environment for fraud and abuse. What we're seeing here in these cases that have emerged since March of 2020, which have a COVID-19 dynamic to them, is we are seeing exactly what you would anticipate based on the way that our lives have really changed. Right now, testing, vaccination, and what to do when you get sick with COVID is at the forefront of everyone's mind. And what that intuitive, sort of obvious dynamic has presented for prosecutorial action is that we're seeing lots of telemedicine fraud. We are alleged, at least. We are in an environment where if somebody's sick, they don't want them in a doctor's office. Well, what that creates is this opportunity for the relaxation of certain regulations about how doctors can see their patients. We have relied a whole lot more on platforms such as this with video conferencing, and with certain aspects of that, that's created an environment that's really ripe for fraud in terms of the billing for that process. There is telehealth right now is basically the Wild West. The rules have been significantly relaxed. Providers can at the early days of the pandemic, it was all hands on deck. You had, orthopedic surgeons opening their offices to COVID testing. And the restrictions on practice were relaxed, that in no area more so than telehealth. There's also a fairly significant uptick, and we're going to talk about this in a little bit more detail with some specific case studies in a few moments, but there has been a significant uptick in fraudulent billing claims to Medicare for medically unnecessary procedures related to the pandemic. And some of the schemes that have been charged at this point really just are no more than just a gross at taking advantage of the environment that we're in, because there are just so few checks and balances right now on the healthcare system because of the ranging impacts of the pandemic. And it goes without saying that when you have essentially free testing, treatment, and vaccinations being offered throughout the United States to combat the pandemic, there's also these opportunities for anyone with a nefarious motive. And one other dynamic that I think plays into where we very well might be heading in terms of new record highs for healthcare prosecutions is not just the large national and international task force that have been assembled by the Department of Justice and agencies like HHS, but early in the pandemic, in sort of the days when we were still figuring this out, and it was still hopeful that in a couple of weeks this thing would kind of fizzle out and we would be back to normal. Well, here we are 2 years later, and the early assembled coronavirus fraud coordinators have really, their job has expanded dramatically. In each of the U.S. attorney's offices throughout the United States and indeed the world, because there are U.S. attorney's offices in U.S. territories offshore, like Puerto Rico, the Virgin Islands, Guam, and the Northern Mariana Islands. Each of those 93 U.S. attorney's offices is tasked from the Department of Justice with having a coronavirus fraud coordinator. The early days, what they were doing was that particular coordinator was principally charged with enforcing some of the issues that were developing with PPE and ventilators and what have you. That the scarcity of that equipment is sort of fizzled down, and you don't read a lot about criminal prosecutions associated with hoarding, price gouging, or other illicit conduct associated with those pieces of life-saving equipment. But what you are seeing is that the task of those coronavirus fraud coordinators has actually morphed into one of a policing fraud. So we have, on the one hand, the strike force establishing these global dragnets to take down large-scale fraud, and at the same time, we have on a very local, super focused level, we have a person or team assembled in each of these 93 U.S. attorneys' offices throughout the world, focused heavily on just combating what the ramifications are from the criminal justice perspective of the pandemic, and that has principally morphed into almost an exclusive fraud and abuse role at this point. You couple that from the big picture level of the strike force to the hyper local level of these coronavirus fraud coordinators, and you layer in the fact that the fraud section, which is driven out of DC, is now hyperactive, perhaps more so than ever before in just New Jersey, where I'm sitting right now. Prior to about 4 years ago, the fraud section was never active in New Jersey. There was sort of this territorial turf battle between the U.S. Attorney's Office in New Jersey and the fraud section based out of DC. And at the change of the last administration, that ended, and the fraud section came in. And the way that works is the prosecutorial teams, who are essentially directed out of Washington, D.C., come in and embed into the various U.S. Attorney's Office and build cases in those local jurisdictions. But like the strike force, the fraud section has that national sort of reach, perhaps unlike some of the more localized activity by the coronavirus fraud coordinators. Take those three dynamics and layer on the fact that it's been a all hands on deck approach. We have federal agencies from basically every single department imaginable working on COVID related frauds. You have one heck of a government effort to combat what it perceives as a existential threat to our healthcare system. Jess?
And yeah, Matt, I just want to interject real quick. So you're talking a lot to us about the criminal activity, and we may have clients wondering, well, how does this pertain to me, right? So I want to clarify that this increased activity and investigations isn't just relevant to companies that intended to commit a fraud. For example, creating a fictitious company or blatantly billing for services not performed, but it also impacts companies that thought they were doing everything right, but may have put some new procedures in place or started a new line of business quickly and made mistakes in the implementation of those programs. So can you just elaborate on why this doesn't only impact those clearly fraudulent companies and how it kind of is much broader and covers the entire healthcare sector?
Well, there's really two principal reasons for that. The first one is a matter of policy. The Deputy Attorney General, Lisa Monaco, in recent weeks, in fact, Jess, it happened to be at a conference that you and I both attended at the ABA White Collar Conference in Miami, announced sort of a sea change in prosecutorial philosophy at the Department of Justice under the Biden administration. Certainly a reversion to a former policy under the Obama administration that was memorialized in the now famous Yates memo. We had a shift from the Obama years in the Yates memo to what was the Rosenstein memo, essentially under the current DAG, Lisa Monaco, back to what was an Obama era prosecutorial philosophy of in terms of corporate wrongdoing under Yates' memo, which is now the philosophy of the DOJ, is to prosecute individuals for corporate wrongdoing. So while corporations can have the greatest intentions, there's always going to be weak links. There's always going to be people that are self-motivated that are going to respond to greed. And one of the challenges of operating an organization where you strive to do the right thing. I don't think anybody, very seldomly, an organization sets out to just be a fraud. That's a pretty nefarious actor. But nonetheless, organizations have bad apples, and you know what they say about the bad apple. And with the prosecutorial policy espoused by the Yates memo, and now renewed under the pronouncements from DAG Monaco in the recent weeks, we have this shift back to ferreting out individual actors rather than punishing corporations. So we have XYZ healthcare company, and they have 20,000 employees, and some of you that are paying, that are listening to this webinar this afternoon may very well be among those types of organizations. You can't necessarily control every single individual in your organization. Your organization is just simply too large. Where people are motivated by self-interest, they're going to engage in misconduct. That reality has to be first and foremost. But what you have under some of the prosecutorial policies that have been espoused are a real need to implement certain controls in your organization that are intended to first and foremost ferret out fraud. And if you don't have them, okay, your organization is not going to withstand the actions of those people who are motivated by nefarious motives. So one thing you can do if you're that organization is have policies and procedures in place, have robust compliance programs, robust training on those compliance programs, and the ability to go to the government in the event that something happens and say, hey, this is what we do. That's how it's gonna play out in real time in some of these investigations. And then the other thing is, with a shift back to the Yates memo from a DOJ policy perspective, it's really incumbent upon these organizations, again, none of them setting out to be nefarious actors, and most of them, especially in the healthcare space, setting out to do the right thing and help people. You're going to have an affirmative obligation to conduct internal investigations under circumstances where you feel or where there is reason to believe that there is misconduct in some of these areas. And what that means is you're going to have to engage counsel, outside counsel, to conduct those investigations at an early phase. You're going to have to, if you want to get cooperation credit under the Yates policy, you're going to have to identify the individuals and identify and share your findings about their misconduct and take appropriate corrective action. That puts a lot of responsibility on corporate America. And under the Department of Justice's policy, they are relying on corporate America to be an active partner. And in no area of practice, perhaps more than healthcare, are we going to see a dramatic uptick of these types of internal investigations that look into specific actors based upon information. And that's the low-hanging fruit is this organization that just is completely fraudulent. They create a telemedicine health operation to defraud Medicare. That's sort of the low-hanging fruit. The real scary thing, and from if I were a general counsel in a healthcare provider organization, whether it be a small doctor practice or a very large and robust hospital group, I would be, what would keep me up at night would be to ensuring that the organization doesn't face an existential threat from the inside, from one of its employees that goes rogue, because these organizations are simply too large to have a pulse on everybody's motives. And under the policies of the Department of Justice, you need to, upon first sight of some warning sign that you knew or should have known was a badge of fraud, for lack of a better term, you got an obligation to look at it in order to keep your organization out of the fray. And that requires uh, a lot of intense control. It requires a lot of intense training on your compliance programs, and it requires a sense for and an appreciation for what some of the telltale signs are of a fraud in your organization. Because with all of this activity sort of flying around, it doesn't just target, you know, BS organizations that are designed to defraud. It targets the real core of our healthcare system, and those are very legitimate organizations. And the way those organizations stay out of trouble is they have to uh, engage, conduct an investigation, and fully cooperate with turning over the nefarious actors. Otherwise, they get sucked into the fray by virtue of the fact that these people are conducting these activities.
Great, thanks for that. I know I kind of put you off on a different subject there, but we've got another polling question, Rachel.
Thank you. So our second polling question, the National Rapid Response Strike Force was established in what year? 2019, 2020, 2021, or none of the above?
It looks like most people are getting this one right too.
All right,
Hint.
20 more seconds.
Hint, it wasn't this year. So change your answer, 25% of you.
All right, 5 more seconds. I'm gonna go ahead and close it out. And here are the results.
Yeah, so the correct answer, and the majority of you got it again, is 2020. It's pretty astonishing that they've been so productive in just that short space of time. But I think that's going to lead to, as I suggested, a continued upward trajectory in criminal and civil enforcement action against healthcare providers.
Thanks, Matt. And I know you were going to take a dive into some of the types of these post-pandemic prosecutions that we have been seeing in the healthcare industry.
Sure, yeah, and just to put it out there once again, this is intended to be interactive. We have about 4 different case studies that are fairly recent, which I hope can shed some light on the types of activities that are being prosecuted right now. But by all means, if you have some specific questions, please put them in the chat. I've got it open on my other screen here, and I know Jess, you do as well. So we'll try to field those questions as they come in. I've taken a few headlines, and they all happen to be from 2021. So there's a fair probability that these are the very type of cases that the strike force is bringing, and these cases have not yet borne out into the statistics that we shared with you for fiscal year 20 from the annual report. And it's cases like this that make me very confident in my assessment that the healthcare space is going to continue to be a very, very fertile ground for these types of cases. And when we complete these case studies, I want to leave you all with sort of some best practices and some telltale signs, if you will, of when the government is sort of knocking at your door, because it doesn't always take form of, you know, a couple of agents showing up on a Friday afternoon asking to speak with whoever is in charge. There's some more subtle things that happen in the lead up where you can get out in front of this early. And like I said, given the shift in policies at DOJ, moving back towards prosecution of individual accountability, you may have an opportunity to preserve what is an otherwise legitimate organization and nobly rooted healthcare organization before before the cancer of certain individuals might taint the whole team. But in this one from May 2016, and I've just really reproduced the headlines on some of these these slides at this point, that this was a really significant takedown, and it was 14 defendants. It was across 7 federal districts. So this was a multi-jurisdictional collaborative effort. And basically what the alleged scheme was that they were offering COVID-19 tests to Medicare beneficiaries at senior living facilities. So just imagine this. This is a everyday occurrence for a totally legitimate business. No greater a population was impacted by COVID-19 than those in long-term care facilities. And that this is a national organization of these types of facilities, and they were providing COVID-19 testing at these facilities. They were also creating COVID-19 drive-through testing sites. Remember those, and other testing facilities where they basically were preying on the fact that people really wanted to get tested. In those early days, nobody really knew what was going on. There was a scarcity to the test as well. They brought these large sums of people in. They collected their personal identifying information associated with the process of getting them tested, and they took either a saliva or a blood sample. And then it's alleged by the government that this national organization of providers then took that information and used it to bill federal entitlements programs like Medicare and Medicaid for all kinds of medical tests associated with the individuals that they identified in that initial testing phase. So a large percentage of those individuals got tested, got their results, either got treatment or didn't, and then moved on with their life, because this was sort of a one-stop shop for healthcare. Similar to the phenomenon of the telemed, we really never had drive-through anything associated with healthcare before this pandemic. But lo and behold, because of what we learned about being outside and the safety associated with it, we started to adapt, and healthcare started to take on a new shape. Well, lo and behold, these people come in, get tested, their information is in the system, and now nefarious actors begin to order a bunch of deemed medically unnecessary testing and treatment, many of which never occurred for these people because they were a transient one-time transaction for testing, and they build the program for it, because once they had a patient file on these individuals, it was essentially fair game. You want to go to the next one, Jess? I think the lesson from that is that many of the individuals are associated with a national provider network, and this case hit the Western District of Arkansas, the Northern District of California, the Central District of California, the Southern District of Florida, Middle District of Louisiana, the District of New Jersey, and the Eastern District of New York. And that's a heck of a large provider network. Again, the corporate, to your point earlier, Jess, the corporate entity there was not charged. These actors, these providers at the down the chain, if you will, are the ones that were charged, as well as some corporate executives. So it really is a case study on identifying and ferreting out potentially nefarious actors working within your network at an early phase, and trying to avoid consequences to the corporation, and that there couldn't be a greater example of that than this one. Another one coming out of the September 17th of this year really is what I mentioned previously. This is again a national healthcare fraud, which alleges that it spanned 43 criminal defendants in 11 districts related to telemedicine. In this one, it's alleged that the telemedicine executives allegedly paid doctors and nurse practitioners to order unnecessary durable medical equipment, genetic and other diagnostic testing, and pain medications, either with or without any patient interaction or only a brief telephone conversations with the patients they had never met or seen. Again, there couldn't be a more spot on example of what's going on as a consequence of the relaxation of the telemedicine rules associated with the pandemic than this case. If your organization is engaged in any form of telemedicine, there is no single greater area right now that you need to have effective policies and compliance controls than in connection with your telemedicine operation. While it is permitted, in fact, it's very valuable in connection with what we're experiencing as a result of the pandemic. Again, I mentioned to you, I'm on the recovery side of having been COVID infected recently myself. I can tell you, I talked to my doctor on Zoom, and but it's critically important that if you're engaged in any form of telemedicine, that you are you have compliance programs that help and support your operation. A couple more examples have also come into the play in terms of the classic laboratory kickback scheme.
I just want to interject real quick. We have to do another polling question.
All right, our third polling question. What federal district was not involved in the major DOJ COVID-19 related takedown announced on May 26, 2021? Central District of California, Eastern District of New York, District of New Jersey, or none of the above? We'll be mindful of everyone's time, so leave this open for 15 more seconds. Please reminder to get your answers in to get CPE credit.
And remember that one involved 7 major federal districts. So just as a hint.
All right, 10 more seconds.
Based on the percentages, it looks like most of you have this one correct as well.
Yep, and I'll go ahead and share the results real quick.
And the answer is none of the above. All of those districts were involved in this major takedown, and this is sort of a prime example of the power, scope, and breadth of the strike force that we were talking about earlier.
Thanks, Matt. And I'm actually going to skip ahead to the 2 next case studies because we have a few minutes. And I think one of the main things that everybody wants to hear is what you touched on earlier and what are those signs of an investigation? Yeah,
sure. While the pandemic has really brought us to sort of understanding a new dynamic to potential healthcare fraud, the ways that the government is policing these and the telltale signs that you can use to help you understand whether you may or may not be in the crosshairs of a government investigation have not changed. And I would say fairly tongue-in-cheek, there is a lot more to an investigation than simply agents at the door. Obviously, agents at the door involve search warrants. If you have agents there, then you got a problem. But oftentimes subpoenas come through, and they have sort of they're couched in terms of a request for documents. And if you're a large enough organization, you start to see them fairly frequently, both on the civil side and maybe a little on the criminal side. If you get a federal criminal grand jury subpoena, that is a significant event that triggers a host of issues for your organization, and the Department of Justice has an affirmative obligation to identify your status in the investigation as one of witness, target, or subject. That's literally in the prosecutorial manual, the Justice Manual. You know, they lose their job if they don't tell you what your status is. So engaging at that moment before you produce documents and understanding what the organizational status is in the investigation is critical, and that should be done through a white-collar criminal defense lawyer with experience navigating these healthcare claims. It's not okay to have, you know, in-house counsel or the person who does your slip and fall work respond to this type of complex issue. These are very nuanced and very impactful documents in terms of federal grand jury subpoenas. The other one in healthcare in particular is driven by the False Claims Act, and that's the civil investigative demand. It's one of the most powerful tools in the federal government's disposal in the healthcare industry in particular. It is really, really dangerous because I have never yet been involved in a case where a civil investigative demand has been issued without a parallel criminal prosecution team assembled and part of the group that's using the tool to elicit information. It shouldn't go as a surprise that it's easier to get information because of constitutional constraints with a civil discovery device than a criminal discovery device. But in circumstances where a civil investigative demand, it's almost always the case and entirely proper that the civil and the criminal authorities are actually talking, and the line between them is blurred completely. No more so than in the healthcare space. And civil investigative demands are used all of the time in order to gather information to support a criminal investigation. So don't ever take sort of the approach that this is a civil investigative demand. The only thing that's going to happen is some kind of monetary penalty. We'll figure it out. No, if there's a civil investigative demand, it's likely that there's a criminal prosecution or a criminal investigation behind it. If you see things like accounts frozen or other strange financial activity, that's usually a telltale sign that there's some sort of prosecution afoot as well. The government has millions of tools at its disposal to freeze assets and do creative things to secure what it believes are the proceeds of a fraud on the front end, even before conviction or judgment. And it's important that you take the appropriate steps and contact an experienced white-collar defense lawyer if you see things like that as well. We talked a fair amount about data analytics, and suffice it to say that they're driving virtually every healthcare case that I've seen in the past 10 years. We've also talked a fair amount about a coordinated approach from multiple federal agencies. What that means most critically is that there's a lot of inroads into your organization in the healthcare space because these various organizations all have different expertise. The classic example is, remember, Al Capone got taken down from a tax case, and that meant that the IRS is involved. And one of the classic ways that the sort of backdoors is in an expanding way, perhaps, is through financial investigations that morph into other things, especially in tax, especially when it comes to medical billing. And then finally, whistleblowers. Again, the insider threat is perhaps the most existential threat, the most significant existential threat to an organization. Relators is a specific term of art where a whistleblower has provided information to the government, either as a cooperating witness or as more specifically as a key TAM plaintiff. The False Claims Act actually incentivizes whistleblowers to file key TAM complaints because it pays for them to do so. They get a percentage of the recovery. It's a civil complaint. It gets filed under seal. Nobody knows about it in many instances for a period of years. During that period of years, the government goes and investigates that allegation that's set forth in the civil complaint and makes a charging decision during that time. And only after they make that charging decision is the civil complaint unveiled, so to speak, or unsealed. And in many instances, that means you both have to combat a civil complaint and a parallel criminal investigation that flows from it at the very same time. So the idea that we could talk all day about whistleblowers and how to protect your organization from whistleblowers, but perhaps in no space more than healthcare is a whistleblower turned relator a significant existential threat.
And with that, Rachel, you want to hop in for the fourth polling question?
Yep. Thank you. So our fourth and final polling question: what statement is not correct of civil investigative demands? Generally does not mean there is a parallel criminal investigation, an optional compliance step, and is the government's way of asking a provider to voluntarily participate in an investigation. It is a sign that the case will stay civil, and the worst that can happen is a monetary fine, or they are all false.
I hope this one is intuitive. If you're voting for optional compliance step, you are wrong. Change your vote.
All right, 10 more seconds.
And the overwhelming majority of you have voted the right way. They are all false, and in particular, it bears repeating. There is a small percentage of people that voted that the case will stay civil and the worst that can happen is a fine. That is not the case. Every civil investigative demand that I've ever been involved with, when you peel back the layers of the investigative team, has a criminal prosecutor and a criminal investigative team behind it. And that's a dangerous proposition because, again, civil discovery is much easier to secure than criminal discovery, but there's nothing wrong with them blurring the lines and using it interchangeably in each case.
Great, thank you, Matt. And with that, we're going to wrap up for the day. So we thank you for being here. Again, your contact information is on the screen, so I encourage anybody to reach out if they have any further questions.
Thank you very much for having us, and wish everybody a happy Thanksgiving.